Hi friends from around the world. We are now in June 2023. That means that the sunrise period, to which I referred in previous videos, is over and the unitary patent is now operational. That is good news. That is, after many years of waiting, we have the unitary patent and you can apply for the unitary patent as from now. Now there's one thing I want to be clear about for you practitioners from around the world. You don't need to make much administrative or learn much administrative stuff to teach your people too much administrative issues. So it is all about the administrative procedures of what has been before. You know the EPO, the European Patent Office. You know the European patent, which is ongoing since 40 years. And with this, you have 95% of the unitary patent already in with regard to how to apply the patent. The other stuff is more strategic, and you have to learn it in order to pass the right information to your client so that your client is able to make the right decisions in his favor. Now, let's talk a bit about the patents, the EPO, the European patent. And you know that the European patent is being filed at the European Patent Office in Munich, that the European patent is not a unique title for different countries. It is one title for each country. That is what you get at the end. You get a German patent, you get a Spanish patent, you get an Italian patent. If you have applied for it, that is what you get. Individual national patents. And you have to continue to follow up with the national offices. You have a European phase and a national phase. And once you get the patent, you have to follow up with the national offices and you litigate in the national courts. That is what you have with the European, quite expensive as well. That's what you have with the European patent, and you know all about it. Now, the unitary patent, as from 1st of June 2023, operational, right? You have one title for, well, in the beginning, 17 countries. It is not for the whole European Union, because some countries have not signed and some countries have not ratified, 10 in total. So 17 countries have signed and ratified, therefore are participating in the unitary patent system, and you get one patent for 17 countries. The big ones are in, so Germany, France, Italy, Spain, they are all, the Netherlands, they are all in, Denmark, they are all in, but some are not in. So Spain is not in, for example, and Poland is not in, and Croatia is not in, and the others, they have signed up, but not are participating at that moment because ratification is not in. So the scope is a bit different. One title at this moment, June 2023, for 17 countries. One patent, 17 countries. That is what you get with the unitary patent. And it is costly, less costly than the European patent. We had a video, in a previous video, I talked about the cost issue. So roughly it is 4 countries is the cost of one unitary patent. So it is much more advantageous from the cost perspective to file for a unitary patent than for individual patents if you want more than 4 countries. Litigation is another issue. The Unitary Patent Court, which is a pillar of the new system, the Unitary Patent Court in Paris and Munich, is the responsible court for unitary patent. There are no other. So there's no other possibility for you to escape that. Unitary patents are litigated in the Unitary Patent Court. That cannot be different because you have only one title, right? And you don't want to have a divergent judgment from Germany in favor and from Spain against. So what do? No, that cannot be different. So Unitary Patent Court, one court only, and that is the, so to say, the fate of the patent, either favorable or the other way around. So this is what you have and what you don't have. What is the, well, when can you apply for the patent? As of June, you can apply for that patent. So I said in the beginning, there's not much difference, and until the patent is granted by the EPO, there's no difference between applying for a European patent or for a unitary patent. And this can take a year or more in the proceedings. So everything stays the same until the patent is granted. And once the patent is granted, then you have a 1 month either to file as a normal European patent, so for all these countries which are participating in the European patent scheme, or you can apply for a unitary patent, or you can apply for both of it. Why would you apply for both of it? Why would you apply for unitary patent and the patent in Sweden? Well, having as a background the trademarks and designs, where we have a unique title for all the member states of the European Union, when we introduced that to the public, to the practitioners and to the clients, it was possible also to make both, so have a unitary title and a national title. And there were people, they taking advantage of it, so they maintained both. They maintained their national title, and on top of it, they wanted to have a unitary title. And well, here the possibility exists at the same time. So it is a kind of strategic issue for the company or for the practitioner, whether they want both or they want alternatively either the national route or the unique title, unitary route, in order to pursue, or both. This has to do, I talked about it already about the central attack. So if you have a central attack, and that is in the unitary patent the case, you have only one court and one judgment, and that is the fate of the patent. And if it is defavorable for you, so you have lost the patent. And if you have maintained a patent in Sweden, for example, then, well, you have still the patent in Sweden, which is not affected by the central attack of the unitary patent. So that is the reason why you have not exclusivity between one and the other. So it is all the same until the moment you get the patent granted, and you can either ask for unitary patent, you can ask for the European patent, or you can ask for both. You know, there's a cost issue behind, so you will not take this decision very lightly. And then what we have is the opting out and opting in. We talked about it. So the sunrise period has ended, 1st of June 2023. Sunrise period, we don't have it. If you don't know what it is, please look the previous video. And in this stage where we are now, unitary patent is operational. you can still have, well, you have a unit. If you ask for a unitary patent, you can't opt in or out. You are in the Unitary Patent Court lane. But if you have a European patent, even an actual or a previous one from 5, 6, 7 years ago, then you can also ask for the opting out. So if you have a European patent and you don't do anything, it will be necessarily litigated in the Unitary Patent Court, in this new court where, well, for some it is a kind of difficulty. They don't know exactly how they will judge, and well, the central attack, etc. They don't know exactly. Well, they have the possibility to opt out and go for the national courts, just like before. But you have to do something in order to be in the previous status. That is not the other way around. So you have to opt out, and you will be on the national route, as in the previous situation, as it was always. You will litigate in the national courts. You can do this unless for 7 years. So there's no deadline here you have to care about, but there is a possibility that you're being sued on the UPC level, and then it's too late. So then the choice is done. You cannot, once you have a litigation pending at the UPC, Unified Patent Court, then you cannot opt out. That's too late. Or once you are suing somebody in the UPC, you cannot opt out if you don't like the judges. No, that's not possible. But what you can do is, once you have opted out and you have no litigation pending, you can revoke the opting out. So you can go back one step back to the national level because you have reconsidered, because you think that this is better for your interest, because your strategic aims, objectives are better served by that way. You can revoke the opting out, and then you are again in the unitary patent system. But then it stops, so you cannot go back and forth and back and forth. That is not possible. So you revoke once and that's it, and then everything is being done. But you have 7 years to do so. So that is what I wanted you to know. This is good news. Let me wrap this up. You have a European patent, or you have, and you can opt out in order to get the previous status, or you can do nothing and you go into the litigation with the new Unitary Patent Court in Paris and in Munich. And the unitary patent, once you have all the same, so you don't have to learn a lot about the new unitary patent. It is cheaper, that's what you need to know. It is a unitary title for 17 countries. Other countries will join the unitary patent system, and it will extend to those countries without paying more fees on that. And you have this possibility once you get the patent granted by the UPC. So there's no national phase, no national patents, no national offices, no translation with regard to the national offices, and no renewal at the national office. There's nothing like that. So thanks for tuning in. That is the good news. I want, in a timely fashion, bring it to you. Thank you.